Welcome back to the Consumer Defense Lab. This is the Friday case study that follows our week on standing. Before we begin, the scope. Everything in this video is legal education, not legal advice. We are teaching a method of thinking about consumer cases. We are not your lawyers, we are not representing you, and nothing here is tailored to the facts of your matter. If you have an active case, the right move is qualified counsel in your jurisdiction. Hold that frame for the next 7 minutes. This week, the lab built one idea from 4 directions. Standing is the doorway. Before a court reaches whether you owe anything, it has to answer a prior question. Is the party in front of the court the party entitled to be there at all? If the answer is no, the case does not get through the door, and the merits never matter. Let me separate 2 things people blur together, because the precision is the whole game. The first is constitutional standing. In federal court, Article 3 limits judges to real disputes between properly injured parties. The plaintiff has to show 3 things: an injury that is concrete and actual rather than abstract, a causal link between that injury and the defendant's conduct, and redressability, meaning a favorable ruling would actually fix the harm. Injury, causation, redressability. Those 3 travel together, and the party invoking the court carries the burden on all 3. The second is the real party and interest requirement. Under Federal Rule of Civil Procedure 17A, an action must be prosecuted in the name of the real party in interest. Put plainly, the named plaintiff has to be the one who actually owns the claim it is suing on. State courts apply their own versions of the same principle, and most consumer collection suits live in state court. Here is the distinction that keeps you accurate. In a debt buyer matter, the live question is almost never whether a debt exists somewhere in the world. The live question is whether this plaintiff has proven that it specifically owns this specific account and is therefore entitled to enforce it. That is a proof question and a party question. It is not a theory that the debt evaporated. Now the study. We will use the lab's running matter, Martinez versus Lakeview Financial Group. The facts are a teaching composite, built to show the pattern, not any one person's case. A consumer, Ms. Martinez, is sued by Lakeview Financial Group, a debt buyer. Lakeview did not originate the account. It says it bought a portfolio that included her balance. To get through the doorway, Lakeview has to be the real party in interest as to her account. So the question on the table is simple. Prove it. What does Lakeview put forward? A bulk assignment, the kind of document that transfers thousands of accounts at once from a seller to a buyer, and an affidavit from someone who reviewed business records. What is missing is the connective tissue. The bulk assignment references a portfolio, but nothing in the record ties Ms. Martinez's specific account to that portfolio with account-level proof. The affidavit describes a process in general terms, but the affiant shows no direct knowledge of how this account moved from the original creditor through any intermediate buyers to Lakeview. That gap is the standing failure. Not because the gap cancels the debt. The obligation, whatever it is, may be entirely valid. The failure is that Lakeview, on this record, has not shown it is the party entitled to enforce it. The burden was theirs, and they did not carry it. How does that get raised? In federal court, a challenge to standing goes to the court's subject matter jurisdiction, and the vehicle is a motion under Rule 12b(1). Standing is jurisdictional, which means it cannot be waived, and a court can raise it on its own at any stage. Where the question is real party in interest under Rule 17 rather than constitutional standing, the rule builds in a caution. A court will not dismiss immediately for a real party in interest defect. It allows a reasonable time for the right party to ratify, join, or be substituted. So the move is rarely a knockout. It is leverage. It forces the plaintiff to produce the proof it should have had before it filed, and very often that proof is exactly what is missing. Now hold the line with me, because this is where discipline matters most on a public channel. A defective or incomplete chain of ownership is a reason the plaintiff may fail to prove its case. It is not a reason the debt is void. Arguing that a broken assignment or a securitization structure makes the obligation disappear is a theory courts treat as frivolous, and it can draw sanctions. The lab does not teach it. We attack proof, we attack standing, we attack conduct, all under recognized rules. We never argue the structure erased what you owe. So what is the takeaway from the doorway? Before you ever reach the merits, ask the first question. Is the party suing the party entitled to sue, and have they proven it on this record? Make them prove it. In a debt buyer matter, that single demand, properly raised, often reveals that the case was built on a portfolio document and a general affidavit, with the one link that actually matters left out. That is standing as the doorway. Next week, we move one step deeper, from who is entitled to be in court to whether their documents can even come into evidence. That is authentication and the business records question, and it is where the Department of Evidentiary Studies lives. Until then, keep the scope in mind. This was education, not advice. Study the method and bring it to someone qualified to apply it to your facts.